Can an injury be work-related if it does not occur on the employer's premises? It's called the coming and going rule. If you work at one specific location, like say that you're coming, this is your place of employment, and you're involved in a car accident out on Butler Pike, you don't get workers' comp for that. You don't generally get workers' comp for that if you have a set location where you work. If you're reporting to the plant and you're 500 yards away and you're in a car accident on the road, it's not going to be covered. If you're in their parking lot, you're included. That's considered the premises. So if you park your car 25 minutes, half hour before work, and you park your car and you're walking in and you slip on ice, or you just fall and slip, or you get hit by another car in the parking lot before you punch in, that's covered by the Workers' Comp Act. The same applies for leaving from work. So you punch out and you're walking out to your car, and then as you're going out to get the car, you slip and fall on your way to the car, that's going to be covered. Now, a subtle nuance in that is any deviation from leaving, going to the car, anything you do that could be considered your business and not the company's business, and the company's business includes you coming and going to work. But the company's business won't include you going over to maybe some broken up pallets because you got a wood burning stove and grabbing that wood and bringing that wood back to your truck. If you fall going to get that wood, they're going to try to beat you on that. Now, if they have like some kind of gathering where they're having a retiree party for somebody, or they're having a company picnic, and you're there and you walk and twist your knee at that company event, that's covered. Whether you're technically on the clock or you're not on the clock, if you're there because of your employment, that's covered. In years past, we used to have one shift would play another shift in softball, sponsored by a company, and the company would know they do it and provide the shirts, and guys would be injured playing softball, and they can make a workers' comp claim for that, because the sort of the esprit de corps, the employee relations that a company gets from sponsoring those things is thought to be enough of a benefit to the company that they should be held responsible for any injuries that happen at them. So company picnics, things like that are going to be covered. Anything off premises has to be in some way furthering the interests of the employer. Generally speaking, horseplay and personal missions are not going to be covered. If you're in the parking lot after work and you're messing around with a football, throwing a football with some guy and you twist your ankle or twist your knee, that's not going to be covered. That's not going to be covered. It's got to be things that we can tie to their employment.